Hello and welcome to this session on unfair dismissal, the key changes under the Employment Rights Act. My name is Paul Jennings. I'm a partner in the employment team at Bates Wells. And as the title suggests, we're going to be looking at the key changes underway, upcoming under the Employment Rights Act insofar as they relate to unfair dismissal. In terms of the content today, I'm going to touch very briefly on context. So just looking at the context in which these changes arrive. We'll revisit first principles around unfair dismissal, just a reminder in terms of the current law, so that we can see how the changes bite, a sort of before and after. We'll summarize those key changes, and there aren't many. There are a handful of changes that are going to affect the law relating to unfair dismissal, but they're important. And then we'll touch on some practical points, both some practical points relating to the unfair dismissal regime, but also slightly more widely in terms of the changes coming through under the Employment Rights Act. So dealing first with context, and I think the biggest context factor is the very significant caseloads that employment tribunals are experiencing. So you can see on the screen a line chart that shows a very significant uptick in the number of single claims being recorded in the employment tribunal system. And it really is a system that is in crisis. So the claims are arriving in the employment tribunal faster than they are being dealt with. So it isn't just that the volume is high. Actually, the volume is outpacing the speed with which the tribunal can deal with them. And so the backlog is getting worse. Single claims are a particular pinch point. Open caseload reached 58,000 in quarter 3 of 25 and 26, which is 49% higher than a year earlier. The HMCTS management data shows that cases are taking 63 to 64 weeks to dispose of. But I think that masks the reality. I think lots of people working in this space will be used to seeing claims listed for late 2027, early to mid 2028 and beyond, meaning that in fact hearings are not coming before the employment tribunal for between 18 to 36 months, which is pretty extraordinary given that often you will have a dismissal or an event crystallizing a legal claim. There may be quite a few months before the claim is issued. There will then be a period of early conciliation. There is then administrative time whilst the system processes it for all of that to happen, and then there be a potential 24 or 36-month wait is an extraordinary lapse in time.